Hello everyone. Hope all are fine. In this session, we are going to study one of the important act, that is Industrial Dispute Act of 1947. Now, what's the purpose of Industrial Dispute Act of 1947? The Industrial Dispute Act 1947 came into existence in April 1947. It was enacted to make provisions for prevention and settlement of industrial disputes and for providing certain safeguards to the workers. Say, Industrial Dispute Act 1947 came into existence in April 1947. It was enacted to make provision for prevention and settlement of industrial disputes and for providing certain safeguards to the workers. Industrial disputes are the disputes which arise due to any disagreement in an industrial relations. Industrial dispute are the disputes which arise due to any disagreement in an industrial relation. Industrial relation involves various aspects of interactions between the employer and the employees. Industrial relations involves various aspects like interaction between employer and the employees. In such relations, whenever there is a clash of interest, it may result in dissatisfaction for either of the parties involved and hence lead to industrial disputes or conflicts. These disputes may take various forms of such as protest, strikes, lockouts, the dismissal of workers, etc. Clear? Now, let's start with the definition. Let's start with definition. The industrial dispute means any dispute or difference between employer and employees, employer and employers, employer and workmen. I mean, workmen means employees, workmen and workmen, or employees and employees, which is connected with. Now, what do you mean by industrial dispute? In case if there is any dispute or difference of opinions between employer and employer, or employer and employee, and employees and employee, or workmen and workmen, which is connected with, there is nothing but industrial dispute. Say, industrial dispute may be said to be disagreement or controversy between management and labor with respect to wages, working conditions, and other employment matters. See, what is industrial dispute? Industrial disputes may be said to the disagreement or controversy between management and labor or employees with respect to the wages, working conditions, and other employment matters. That is nothing but industrial dispute. Industrial disputes, in simple words, we can say it is a clash between employer and employee with regard to wages, matters like wages, working condition, and other employment matters. Or we can say controversy or disagreement between employer and employees. That is nothing but industrial dispute. Hope you are clear. Next definition, that is industry. Now, as per section 2, subsection J of the Industrial Dispute Act of 1947, industry means any systematic activity carried on by cooperation between an employer and his workmen for 1 minute. As per section 2, subsection J of the Industrial Dispute Act of 1947, industry means any systematic activity carried on by cooperation between an employer and his workmen for the production of supply or distribution of goods and services with a view of satisfy human wants or needs. Now, what is industry? Industry means it is a systematic activity. It is a systematic activity carried on by the cooperation between an employer and his workmen for the production, supply, or distribution of goods and services with a view of satisfy human wants or needs. It means it's a systematic activity whereby cooperation between the employer and employee as far as production, supply, and distribution of goods and services with the intention of satisfying the human wants. That is nothing but industry. Clear? Next is what say before going for objectives, I would like to tell you the reasons or causes of industrial disputes. It's not mentioned here, but still, what are the causes or reasons of industrial disputes? See, demand for higher wages or allowances, demand for payment of bonus, then demand for higher social security, then demand for improved labor welfare and other benefits like canteen, rest, then accommodation facilities, etc. These are the reasons demand by the employees for these things like higher wages, payment of bonus, higher social security, then adequate canteen facility, rest facilities, accommodation facilities, etc. These are the demands. In case if the employer doesn't satisfy, then the clash arises between employer and employee. There is nothing but industrial dispute. Hope you're clear. These are the reasons or causes of industrial disputes. Okay, let's see next one. That is objectives of Industrial Dispute Act of 1947. Now, what are the objectives? First one, settlement of disputes between employer and workman, employer and employer, and workman and workman. I already told. In the meaning itself, it's clear. What is the industrial dispute? Industrial dispute is nothing but it is a dissatisfaction or controversy between the employer and employer and employee, or employer and employee. Okay, settlement of disputes between employer and workman, employer and employer, and workman and workman. This is the prime objective, right? Settlement of disputes between employer and employee, employer and employee, and employee and employee, or workman and workman. Clear? That is the first objective. Second objective, protection of registered trade unions. See, protection of registered trade unions. See, each and every employee usually register themselves in one or two registered trade unions, right? So the Industrial Dispute Act says, or in objective of Industrial Dispute Act of 1947 is to protect the rights of the employees or the rights of the trade union, rights of the employees, those who are involved in trade union. That is nothing but second point. Hope you're clear. Protection of registered trade union rights. According to the act, which trade union is registered properly, then protecting such type of trade union rights. That is the prime objective of Industrial Dispute Act of 1947. And third one, prevention of illegal strike and lockout. See, legally, the employees can do strike in case if they are dissatisfied with the employer. Okay, in case of illegal strike and illegal lockout, to prevent such illegal strike and lockout, this Industrial Dispute Act 1947 came into act. So that is the prime objective, prevention of illegal strike and lockout. And one more objective, promotion of collective bargaining. See, another objective of Industrial Dispute Act of 1947 is nothing but promoting the collective bargaining of the employees or the workers. Is it clear? Or we can say rational behavior of the, protecting the rational behavior of the employees and protecting the rights of the employees. Is it clear? Next is next heading, that is extent of the act. See, the act extends to the whole of India. It applies to all the industries, whether to be carried on by private owners or by government. See, the act extends to all of India it applies to all the industries, whether they be carried on by private people or by the government. Then the act has been amended time to time. This act is amended time to time. Next subheading, strike and lockout. See, next subtopic that you are going to study under Industrial Dispute Act of 1947 is strike and lockout. Now, what is strike and what is lockout? Okay, say what is strike? A refusal to work organized by a body of employees as a form of protest, typically in an attempt to gain a concession or concession from their employer. Now, what is strike? Strike is nothing but employees are going to refuse to do work to fulfill their needs. It may be increase in salary or providing to get proper facilities, right? So, what is strike? A refusal to work organized by a body of employees. Body means a group of employees as a form of protest, typically in a attempt to gain a concession or concession from their employer or to fulfill their demands. That is strike. Now, what is lockout? See, lockout is nothing but temporary closing of place of employment. See, lockout is nothing but the closing down of the company or temporary closing of the company or a work of employment, a place of employment by the employer, not by employee. Remember, strike is done by employee. It means they are going to refuse to work. But here, temporary closing of place of employment by the employer. See, a lockout is a temporary work stoppage or denial of employment initiated by the management of the company during a labor dispute. Remember, in case if there is a labor dispute, at that time the employer or the company is going to stop the work. Clear? That is nothing but lockout. You got the difference between strike and lockout. Strike is nothing but a refusal to work by the group of employees to satisfy their demands, to fulfill their demands. What about lockout? During labor dispute, the company or the employer is going to stop the work or closing, temporary closing of place of employment. That is nothing but lockout. Hope you're clear. Next is general prohibition of strikes. Now, what are the general prohibitions of strikes? See, no group of workmen may strike in the following situation. First one, during the pendency of conciliation proceedings before a board and 7 days after the conclusion of such proceedings. See, there are various dispute settlement mechanism. In that, conciliation is one among them. Okay. See, in dispute settlement mechanism, conciliation is one among them that we are going to study in later in detail. Okay. Now, see, while take for example, if the group of employees having a dissatisfaction with the employer, and for that they contacted conciliators. Okay, at that time they should not do any kind of strike during those days. That is the first point. Clear? No group of workmen may strike in the following situations: when the case is in conciliation proceedings, when the case is in conciliation proceedings or dispute settlement mechanism, then after 7 days also, 7 days after the conclusion of such proceedings also, the employee should not do any kind of strike. Hope you're clear. That is the first point. Second one, during the pendency of proceedings before a labor court, tribunal or national tribunal, and 2 months after the conclusion of such proceedings. See, when, see, if the matter doesn't satisfy or doesn't settle in conciliation proceeding, then that case goes to the labor court or tribunal or the national tribunal. There is also dispute settlement mechanism. The topic is very important that we are going to study in detail. Okay, so here when the matter is not settled in conciliation proceeding, then that goes to the labor court or tribunal court, then national tribunal. Okay. Now, even if the matter is in court or labor court, it may be, or it may be tribunal, or it may be national tribunal. Even there also, the employee should not do any kind of strike. In the sense, when matter or the case is in a court, then during those days, even after 2 months, the employee should not do any kind of strike. Hope you're clear. When the matter is in, 1 minute, when matter is in conciliation proceeding, when matter is in conciliation proceeding and in labor court or national or tribunal court, in both cases the employee should not do any kind of strike. Okay, hope you're clear. Okay, next is penalty for illegal strike, that's mentioned in section 26 of the act. Penalty for illegal strikes. See, any workman who commences continues or otherwise acts in furtherance of a strike which is illegal under this act shall be punishable with the imprisonment for a term which may extend to 1 month, or with fine which may extend to rupees 50, or with both. Now the fine is increased. Okay, this is the old one, amendment has taken place. Okay, see, penalty for illegal strikes. Now, in case if some group of employees do a illegal strike, then the imprisonment will be 1 month, or with rupees 50, or with both. Okay, then penalty for giving financial aid to illegal strike. If some third party is going to support your strike, then what about the punishment? Any person who knowingly expends or applies any money in direct support of an illegal strike is punishable with imprisonment for a term up to 6 months, or with a fine up to 1,000, or with both. Is it clear? Any person who knowingly expends or applies any money in direct support, if anybody support, third party support the employees to do a strike, their punishment will be 6 months, or with a fine up to 1,000, or with both. Hope you're clear. Next is lockout. What about lockouts? It means closure of the place of business, not closure of business itself. Remember, this is a lockout means it is a temporary closure of place of business. It's not a closure of business itself. Hope you're clear. Now, what about penalty for illegal lockouts? See here, what about the penalty for illegal lockouts? An illegal lockout is punishable for a term extending to 1 month, or with fine up to 1,000, or with both. See, what about the penalty for illegal lockouts? An illegal lockout is punishable for a term extending to 1 month, or with fine up to 1,000, or with both. See, what about the penalty for illegal lockouts? It may be 1,000 fine, or 1 month imprisonment. Is it clear? Imprisonment means jail. Okay, clear? Now, what about layoff? See, layoff is nothing but suspension or termination of employment with or without notice by the employer or management. Layoffs are not caused by any fault of the employees, but by reasons such as lack of work, cash, or material. Now, what do you mean by layoff? See, layoff is nothing but suspension or termination of employment. What is layoff? Suspension or termination of employment with or without notice by the employer or management. Layoffs are not caused by any fault of the employees. See, layoff is nothing but terminating the employees by the employer, but the employees mistake was not there as far as termination is concerned. Reasons are to terminate. Reasons for the termination are lack of work or cash or material. There is nothing but layoff. See, if there is no work at all in a company, then the company is going to terminate the employees. That is nothing but layoff. In case if there is no amount, if there is no enough amount to pay, then the employer is going to terminate the employees. That is nothing but layoff. Now, what is permanent layoff? Permanent layoff is nothing but redundancy. We call it as redundancy. Hope you're clear. In industrial undertaking, where layoff provisions apply, only those workmen will be entitled to layoff compensation. See, some industries or the companies, those who comes under the layoff provisions, then such employees are going to get a compensation over on layoff matter. Okay, then no compensation shall be paid to the workman if he refuses to accept any alternative employment in the same establishment. See, when no compensation is paid, in case if the employer is going to give another work or another job in the same organization, at that time, if the employee refuses, then he or she doesn't get any kind of compensation. Remember, one, if he refuses to accept any alternative employment, if the employer is ready to give alternative employment, alternative job, then the employee is not ready to accept it, then the compensation is not paid. Next, if such laying off is due to strike or slowing down of production on part of workmen, if the layoff reason, in case if they do any kind of strike or slowing down of production, then the employees are not going to get any kind of compensation. Okay, then if a workman has been laid off by the employer due to shortage of power or natural calamity, the appropriate government makes an inquiry if he thinks fit. If the authority doesn't communicate the permission within 2 months with the employer, then the layoff is deemed illegal. Then the workman is entitled for all the benefits from the time he has been laid off. See, in case if the workman is laid off due to the reason of power or natural calamity, at that time the government has to do, the appropriate government has to do the proper inquiry on that. Then after that they need to inform it to the employer. Then employer has to inform it to the prescribed authority, it may be a government. Okay, then in case if they are not followed all these things, all the rules and regulations, then the employees are, if the employer doesn't follow the layoff rules and regulations, then the employee are eligible to get all the benefits from the time he has been laid off. Okay, he get full outstanding salary or outstanding wages. Is it clear? He is eligible for all the outstanding salary or wages. Then penalty for layoff. Any employer who contravenes the provisions of layoff is punishable with imprisonment for a term 1 month, which may extend to 1,000 or both. Imprisonment of 1 month or 1,000 or with both. In case of illegal, those who go against to the rules of layoff, and any employer who contravenes, in the sense against to the provisions of layoff, he is punishable with jail of 1 month or else 1,000 fine or with both. Next concept, that is retrenchment. Now what is retrenchment? retrenchment is nothing but forced layoff of employees by a firm, usually to cut down its payroll. See, to cut down the payment or cut down this, cut down the payment, or to reduce the salary, or reduce the outflow of salary. They are forced, the employer forced the employees, or we can say forcing the employee, or without any kind of kindness, they are going to thrown out. There is nothing but retrenchment, forced layoff of employees by a firm. There is nothing but retrenchment. See, no workman employed in any industrial establishment who has been to continuous service for not less than 1 year under an employer shall be retrenched by that employer until he has been given 3 months notice in written indicating the reasons for retrenchment. See, the employer should give 3 month notice before retrenchment. One, no such notice shall be necessary if the retrenchment is under an agreement which specify a date of termination. The first itself, while appointment, the termination date or month or year is mentioned, then this provision doesn't apply. Okay, he need not to, he can remove, at any time. Not any time, he can remove at that particular date, sorry, we specify the date of termination of service. During that particular date, till that he can continue the work. Thereafter the employee can be terminated. Okay, that's the first point. Second one, notice shall be given to appropriate government or such authority, and the permission of such government or authority is obtained. Notice shall be given to the appropriate government or such authority, and the permission of such government or authorities that are obtained. It means before retrenchment, before forcing the employees to terminate, the employer should get a permission from the appropriate authority, is nothing but government. Is it clear? That is the second point. Okay, next, this is important topic, that is industrial dispute resolution mechanism. Now, what is industrial dispute resolution mechanism? It is nothing but it is a mechanism, or it is a tool to settle the disputes between employer and the employees, or employer and the employer, or workman and workman, that is employee and the employee. Okay, so it is nothing but it is a mechanism or tool to solve the problems between employer and employee, especially, and employer and employee, employer and employer, or employee and employee. Okay, so under industrial dispute resolution mechanism, the first point is constituting works committee. There should be a works committee to solve the dispute, industrial dispute. See, any industrial establishment wherein 100 or more workmen are employed, or were employed on any day during the preceding 12 months, may be required by the government to constitute a works committee comprising of equal number of representatives of labor and management. See, if an industry which is having more than 100 employees, okay, then such company or a industry should have works committee to solve the industrial dispute in case if it arises. Okay, then what about the number of members in works committee? See, equal number from government, and sorry, equal number from management, and equal number from employees or workmen. Employer and employee, equal number of representatives of labor and management. See, the representatives, 1 minute, The representatives of workmen on the works committee shall be chosen in the prescribed manner from among the workmen engaged in establishment or in consultation with the registered trade union. Usually, the employees are going to select from the registered trade unions. The main functions of the works committee are to establish a cordial relation between workers and the employers and to resolve the differences of opinion in matter of common interest through negotiations. What is the main intention of works committee is nothing but to solve the misunderstandings or the problems between the workman and the employer, or to solve the difference of opinions between employer and employee. That is the main intention of forming works committee. Hope you clear. What is works committee? This topic is very important. First one is constituting works committee. Now, see here, if a industry or company which is having more than 100 employees, that industry or a company should have works committee. That is the first point. Then the number of representatives from management as well as from employees, that should be equal. Then employees are selected. The representatives from employees are selected from the registered trade union. That is the third point. Then what is the main intention or a function of work committee is nothing but maintaining a cordial relations between employer and the employee, and to resolve the dissatisfaction differences of opinion in matters of common interest through negotiation. Through negotiation, they are going to solve the dissatisfactions or the differences of opinion or clashes between employer and employee through negotiations. That is the first one. Then second point, that is setting up of grievance redressal committee. See here, the employer in relation to an industrial establishment employing 20 or more workmen shall set up one or more grievance redressal committee for resolution of individual grievances. A committee shall consist of maximum 6 members having equal number of members from employer and the workmen. Now, what is grievance redressal committee? The word itself says grievance redressal committee. The employer in relation to an industrial establishment employing 20 or more workmen shall set up one or more grievance redressal committee. See here, if the industry or a company is having more than 20 employees, then such type of industry should have a grievance redressal committee, one or more grievance redressal committee to solve the individual grievances, of an employee. Is it clear? To solve the individual grievances, it may be employer or the employee. Okay, a committee shall consist of maximum of 6 members having equal number from employer and the employees. Hope you're clear. The main intention of forming grievance redressal committee is important objective of forming grievance redressal committee is to solve the individual grievances. Clear? The number is same, that is equal number from employer as well as from employees. Okay, if the industry or a company is having more than 20 employees, then such type of industry should have one or more than one grievance redressal committees. Okay, that is the second point. Third one, that is conciliation proceedings. Say, if the employer and the workmen fail to arrive at a settlement through negotiations, the conciliation officer may intervene as a mediator to reconcile the differences of opinion and help the labor and management in achieving a successful settlement. Now, what is conciliation proceeding? Say, if the employer and the workmen fail to arrive at a settlement through negotiation, if the case is not settled through negotiations, if the matter is not settled through negotiations, that is works committee, right? If the matter is not settled in works committee, then then conciliation proceeding comes. See, the conciliation officer may intervene as a mediator. Conciliation officer is the mediator to reconcile the differences of opinion and help the labor and management in achieving a successful settlement. See, here the mediator is going to guide the employer and the employee to solve their problems, or to solve their differences of opinions. That is nothing but conciliation. Clear? Next is arbitration. Now, what is arbitration? It is a process in which the conflicting parties agree to refer their dispute to a neutral third party known as arbitrator. See, the case in case if the matter is not settled in conciliation proceeding, then the matter or the case goes to the arbitration. Now, what is arbitration? Here, the case is given to the neutral third party, that is arbitrator. Here, arbitration differs from conciliation in the sense that in the arbitration, the arbitrator gives his judgment on a dispute, while in conciliation, the conciliator disputing parties to reach at the decision. See, what is the difference between arbitration and conciliation? Here, in arbitration, arbitrator is going to give a decision, okay, judgment. Arbitrator is going to give a judgment after listening both employers and employee opinion. Okay, then arbitrator is going to give a decision or a judgment. Then what about conciliation? In conciliation, conciliation officer is going to, or conciliator is going to give the suggestions as to the employer and employee. Their conciliator is not going to give any kind of judgment. The employer and the employee is going to settle their disputes by listening the advices of the conciliator. Hope you're clear. In arbitration, arbitrator is going to give a judgment after listening the opinions of employer and the employee problems. In conciliation, conciliator is not going to give any kind of judgment. Judgment is not given by the conciliator. Conciliator is going to guide the employer and the employee. Then the employer and the employee is going to solve their problems. Okay, then the arbitrator doesn't enjoy any judicial powers. The arbitrator listens to the viewpoints of conflicting parties, then he gives his decision, which is binding on all the parties. In the sense, there is not a judicial power to a arbitrator. Arbitrator is going to listen both the parties, then he is going to give a judgment. Okay, the judgment is bound by both the parties. The judgment on the dispute is sent to the government. Hope you're clear. You got the difference between conciliation and arbitrator. Conciliator is going to give advice to the employer and the employee to solve their problems, but in arbitration, arbitrator is going to give the judgment after listening both the parties views. Then both the parties, after judgment, both the parties accept that particular judgment. Both the parties to be bind that particular judgment. That is nothing but arbitration. Next is adjudication. Adjudication. Now, what is this adjudication? The ultimate legal remedy for the settlement and unresolved dispute. See, what is adjudication? Adjudication is nothing but it is the ultimate authority to give or to solve the problems or the dissatisfaction between employer and the employee. That is nothing but court. Here there are three. One is labor court, industrial tribunal, and national tribunal. These three comes under adjudication. Okay, here in that first one, labor court, this is very simple. Labor court, see, under the section 7 of the Industrial Dispute Act of 1947, the appropriate government, by notifying in the official gazette, may constitute labor court for adjudication of the industrial disputes. The labor court consists of one independent person who is presiding officer or has been a judge of the high court or has been a district judge or additional district judge for not less than 3 years or has been a presiding officer of a labor court for not less than 5 years. The labor court deals with the matters specified in the second schedule of the Industrial Dispute Act. See here, under the section 7 of the Industrial Dispute Act of 1947, the appropriate government by notifying in the official gazette may constitute labor court for adjudication of the industrial dispute. Now the government is going to mention in official gazette here whatever the information or the notification of the government that is displayed on the official gazette. Once the notification is announced in official gazette of the government, then it is valid. Remember that. May see the appropriate government by notifying in the official gazette may constitute labor court for adjudication of the industrial disputes. To solve the industrial dispute, the government is going to notify in official gazette regarding appointment of the labor court to solve the industrial disputes. The labor court consists of one independent person. Now, who is that independent person? It may be a retired judge of high court, or else a judge of a district judge. See, he has been a district judge or additional district judge for not less than 3 years experience, and then has been a presiding officer of a labor court for not less than 5 years. 1 minute. See, the judge, it may be high court judge, retired. No, he has been a judge of high court, not a retired judge of high court, or has been a district judge or additional district judge for not less than 3 years. If it is if high court judge is available, then then they decide high court judge, then they take high court judge, or else district judge, or else additional district judge. That additional district judge should have experience of 3 years or has been a presiding officer of a labor court for not less than 5 years. Then the labor court deals with the matters specified in the second schedule of the Industrial Dispute Act. These matters related to all matters other than those reserved for industrial disputes. See, whatever the matters relating to industrial disputes, these matters, okay, these are industrial dispute tribunal, industrial tribunal matters, except that see, except these matters, other matters which goes to the first one, that is labor court. Okay. Now, what is industrial tribunal here? Under section 7A of the Act, the appropriate government may constitute one or more industrial tribunals for the adjudication of industrial disputes. Compared to the labor court, industrial tribunals have the wider jurisdictions. Here, see, what are the matter comes if the case regarding wages or compensatory and other allowances, if the case regarding leave with wages and holidays, bonus, profit sharing, provident fund, gratuity, rules of discipline, all these matters or cases goes to the industrial tribunal, and other matters other than these matters goes to the first one, that is labor court. Is it clear? If the case regarding wages, compensatory or other allowances, leave wages or holidays, then bonus, profit sharing, provident fund, gratuity, rules of discipline, all these matters settled in industrial tribunal. In case other matter comes, then or other cases comes, then goes to the labor court. Last one, that is national tribunal. See here, in case if the case or the problems are not settled in these two, that is industrial tribunal and labor court, then the case goes to last ultimate authority, that is national tribunal. This is the third one adjudicatory body appointed by the central government by the notification in the official gazette for the adjudication in the industrial disputes of national importance. If the case is not settled in labor court or industrial tribunal, then the case or the matter goes to the national tribunal. This is the ultimate authority to solve the disputes, industrial disputes. Hope you're clear. This is about dispute settlement mechanism. Okay, first one, I just repeat once again. First one, they are going to form works committee. If in works committee, if the matter is not settled, then it goes to the conciliation proceeding. Okay, grievance redressal committee is formed to solve the individual grievances, remember. Okay, in case if the employees are 20 or more workmen are employed, then uh, one or two grievance redressal committee need to be formed by the employer. Okay, then third one is conciliation, fourth one is arbitration. Conciliation is going to give advice, arbitrator is going to give judgment. Then next is adjudication which comes under that. There are three: one is labor court, industrial tribunal, and national tribunal. Wages, in industrial tribunal, wages, then matters regarding wages, then other compensatory and other allowances, leave, wages, holidays, bonus, profit sharing, provident fund, gratuity, rules of discipline. All these matters goes to the industrial tribunal, all these cases. Then remaining matters, the other matters goes to the labor court. Then in case if the in both the case is not settled in both, that is industrial tribunal and labor court, then the case goes to the ultimate authority, ultimate dispute settlement mechanism, that is nothing but national tribunal. This is appointed by the central government by notification in the official gazette. So this is the ultimate authority to resolve the dissatisfaction or the clashes between employer and the employees, or employer and employer, or employees and employees. This is about Industrial Dispute Act of 1947. Hope you understood. In case of any doubts, you can contact me. Thank you.